until we have the time to review them. And then we resume this hearing. What I'm saying to you is basically this. If you will trust the American people, they will trust you. But if your effort today continues to conceal and hide documents, it raises a suspicion. I'll close, Mr. Chairman. I know you're anxious. When I was a practicing lawyer a long time ago in trial, and the other side either destroyed or concealed evidence, I knew that I was going to be able to have a convincing argument to close that case. What were they hiding? Why won't they let you see the speed tape on that train or the documents that they just can't find? You know that presumption now is against you because of all the documents that have held back. For the sake of this nation, for the sanctity of the Constitution that we both honor, step up, ask this meeting, this gathering, to suspend until all the documents of your public career are there for the American people to see. Thank you, Mr. Chairman.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Kavanaugh. And thank you also, Ashley and Margaret and Eliza, for being here. I'm going to start by saying that the fact that there is so much angst over a single nominee, a single judicial nominee, tells you everything you need to know about why it is that we need judges now more than ever who are willing to read the law and interpret it based on what the law says rather than on the basis of something else. It also tells you more than anything else you could need to know about the need to restore a discussion of civics in this country, to restore a discussion about federalism and separation of powers, about where power is concentrated and where it shouldn't be, and what the role of each branch of the federal government is and is not. Many of the comments, many of the outbursts that we've had today suggest that we need to return to some of those fundamental principles. And I don't care whether you're a liberal Democrat or a conservative Republican or something in between. These principles apply. They're principles to which we have sworn an oath. And they're principles that I think we would do well to restore and focus on once again. If ever we're to return to an era of civility, we will return to that era on the basis of those foundational structural principles within our Constitution. Over the next few days, Judge Kavanaugh, a number of members of this committee are going to ask you questions. Questions about cases that you've handled as a lawyer, cases that you've decided as a judge, about your record, about your qualifications. Well, on that point about your record and your qualifications, the suggestion that you misled this committee at any point in your previous hearings is absurd. And the absurdity of that suggestion will be borne out in the coming days. I am certain of it. Some of the questions that will be asked of you will, in fact, be fair, and others will be unfair. And I think it's important for us to acknowledge that at the outset. When you look back at history, answering these kinds of questions, this is sort of how the practice of holding these hearings began. So that senators could ask nominees how they might vote, how they might rule in particular cases. But this didn't always happen. In fact, it wasn't until 1916 that this even started. You see, there have been 113 justices confirmed to the Supreme Court so far. The first 66 were confirmed without even holding a hearing. The idea of a hearing is relatively new. It's about 102 years old. We went for between 125 and 130 years under our constitutional republic without ever having a hearing. But regardless, we started having hearings just over a century ago. The very first Supreme Court confirmation hearing occurred in 1916 with Justice Louis Brandeis. After Louis Brandeis was nominated to the court, some called for a hearing. Now, if we're honest with ourselves, if we're honest about history, I think a lot of this maybe had to do with some anti-sentiment fervor and the fact that Justice Brandeis was Jewish. But senators also wanted to determine whether Brandeis would use his seat on the Supreme Court to advocate for some of the things that he had advocated for as a private citizen, as a public interest attorney. They wanted to know how he might vote in particular cases. They didn't ask Justice Brandeis to testify significantly. But they did, in fact, ask some outside witnesses what they thought about his nomination. The next important moment, one could argue, occurred in 1939, when Felix Frankfurter became the first nominee to himself testify before the committee. At the time, Frankfurter was controversial in part because he was born overseas, but senators also worried that Frankfurter was a radical based on his defense of anarchists in court. So again, senators wanted assurances about how Frankfurter might rule in particular cases, in particular, what results he might reach in a particular type of case. Frankfurter, however, significantly declined to engage with senators on those topics and insisted that his public record spoke for itself. Justice Stewart's nomination in 1959 was another turning point. Senators seeking to resist Brown versus Board of Education wanted to grill Stewart on his views on integration. Others still wanted to grill Stewart about his views on national security. So senators turned up the heat a little bit more in that hearing. Like Frankfurter before him, Justice Stewart did not provide substantive answers to their questions. When they wanted to know how he might rule in particular cases, he appropriately declined, just as his predecessors had. 28 years later, 28 years after Justice Stewart came through this committee, the Senate considered Robert Bork's nomination to the Supreme Court. This was another significant turning point, and in my view, remains something of a rock-bottom moment for the Senate and for the Senate Judiciary Committee. Without getting into any of the gory details here, I think it suffices to say that Senator Ted Kennedy and Judge Bork did not agree on certain matters of constitutional law. And Kennedy's response was to savage, unfairly in my opinion, the results that Judge Bork would reach if confirmed to the Supreme Court. The history shows that over the better part of a century, the Judiciary Committee has gradually created something of a new norm, a norm in which members demand that nominees speak about specific cases in return for favorable treatment from the committee as the jurists are going through this process. Now, nominees, for the most part, have gracefully resisted trading confirmation in exchange for promises about how they might vote in particular cases brought before them. To give two famous examples, Justice Scalia refused to say whether Marbury versus Madison was settled law on the ground that it could come before him. And sure enough, last term in Ortiz versus United States, the Supreme Court considered a case implicating the scope of Marbury. Likewise, Justice Ruth Bader Ginsburg created the so-called Ginsburg standard. No previews, no forecasts, no hints. Every current member of the Supreme Court has adhered to a similar principle, what we might call the Ginsburg standard. Even though nominees have not caved to the pressure, I still believe that there are some aspects of the Senate's approach here that might do a disservice to the country and might be frowned upon by future historians. If senators repeatedly ask nominees about outcomes, then the public will be more entitled, or at least more inclined, to think that judges are supposed to be outcome-minded, that that's supposed to be their whole approach to be to judging, that that's supposed to be what judging is in fact about. But this, of course, undermines the very legitimacy of the courts themselves, the very legitimacy of the tribunal that you've been nominated by the president to serve on. Over time, no free people would accept a judiciary that simply imposes its own policy preferences on the country, absent fidelity to legal principle. There's a better way for the Senate to approach its work. This process, in my opinion, should be about your qualifications, about your character, and perhaps most importantly, about your approach to judging, your own view about the role of the federal judiciary. It should not be about results in a select number of cases. Now, you're obviously exceptionally well qualified. Even your staunchest critics would not claim otherwise. Your academic pedigree, your experience as a practicing lawyer, your experience in government, and your 12 years experience sitting on what many refer to as the second highest court in the land, the U.S. Court of Appeals for the D.C. Circuit. You are independent. You've written that, quote, some of the greatest moments in American judicial history have been when judges stood up to the other branches, were not cowed, and enforced the law, close quote. You've said that judges cannot be buffaloed, influenced, or pressured into worrying too much about transient popularity when we're trying to decide a case, and that one of the most important duties of a judge is to stand up for the unpopular party who has the correct position. And you've lived up to your words during your time on the bench. Everyone knows that you served in the Bush administration. And yet, when you became a judge, in only 2 years, you ruled against the Bush administration a total of 8 times. For you, it simply doesn't matter who the parties are. It simply doesn't matter that you may have worked for an administration before you became a judge. The only thing that matters is your commitment to correctly applying the law to the facts of any particular case. As far as your approach to judging, you have appropriate respect for precedent. You've co-authored an 800-page book on precedent that, among other things, explains that a change in a court's membership alone should not throw former decisions open to reconsideration or justify their reversal. You've explained that for precedent to be overruled, it must not be just wrong, but a case with serious practical consequences. You voted to overturn circuit precedent only 4 times during your time on the D.C. Circuit, and each of those cases involved a unanimous decision reached by your colleagues. And you follow binding precedent, even if you believe that binding precedent was itself wrongly decided. You decide cases based on legal merits, not based on the identity of the parties, and certainly not based on any political beliefs that you may harbor. We've already heard that your nomination will somehow be bad for women, for the environment, for labor unions, for civil rights, for a whole host of other things that Americans hold near and dear. I have a laundry list of cases in which you've ruled for people in each of those groups. But there's a more fundamental point here that I think needs to be made. The judiciary's decisions are legitimate only to the extent that they're based on sound legal principle and reasoning. And ruling for a preferred party is not itself a sound legal principle. It's quite to the contrary. Jury-rigging decisions and backfilling legal reasoning to reach a particular result, a particularly politically acceptable result in a particular case, no matter how desirable that result might be in any instance, is not a legitimate mode of judicial decision-making. And no free people purporting to have an independent judiciary should ever be willing to settle for that. So my plea to my colleagues today is that we ask Judge Kavanaugh hard questions. I believe we're required to do so. The Senate is not and never should be a rubber stamp, particularly when it comes to issuing lifetime appointments, even lifetime appointments on the highest court in the land. But if you disagree with an opinion he's written, make a legal argument as to that issue. Explain why you think it's wrong. Don't complain about the results as if the result itself is proof that he's wrong, when you separate out the result from the legal analysis, from the facts and how they interact with the law in that particular case. And don't ask him to make promises about outcomes in particular cases. If it's unacceptable for the president to impose a litmus test, it is surely unacceptable for the United States Senate to do so. Judge Kavanaugh, I look forward to your testimony, and I'm grateful to you and your willingness to serve our country and to be considered for this important role.
Senator